You ready on Mr. Browder? 26M36, Jimmy Browder. All right. There was a motion for a bill of particulars that was filed. People have a response.
What does that entail, Browder?
Specifically, I'm requesting to know which messages in the 43 screenshots I was sent are alleged to be unprotected or criminal, and what dates those are exactly charged. Because right now I have 43 screenshots spanning several months, and I'm unsure which ones are alleged to be the conduct that is charged. I'd like to file a First Amendment motion, but I don't really know which ones I'm addressing.
I think that's a trial issue.
Ms. Garman, did you have any further response?
I can't prepare for trial if I don't know which messages are the charged conduct.
Well, given that there appears to be a large volume of messages over an extended period of time, I think that the defense is entitled to know which of those the people are intending to proceed on. So the court will grant the motion for a bill of particulars. I'll give the people 10 days from today to file the bill setting forth the messages that they are intending to go forward on in terms of prosecution. And we'll set this for further pretrial.
Yes, Judge.
Good morning. The court calls 26M36 People versus Browder. Good morning, Mr. Browder.
Thank you.
Good morning, Ms. Gifford.
Good morning.
This case comes on both for pretrial readiness as well as a hearing on motion. So in your motion to dismiss, I'm looking at the one that was filed June 15th. Let's see. Looks like paragraph 5 contains the statement, "You deserve your karma and I am your karma." Let's see. Paragraph 8, he addresses Ms. Stone as "you worthless whole." Paragraph 9, there's a statement, in brackets, Ms. Stone is not home, so I can't see Bailey. It's all good. Your time is coming. Then there's kind of a paraphrasing about Mr. Browder informs Ms. Stone that Bailey's meds are in her mailbox. I don't know that I can rely on a paraphrasing to determine if it is constitutionally protected because the actual words themselves matter. He then states only good for one thing, and that is a hold to fuck, and even then might catch something, LOL. And then paragraph 11, I wish a slow, painful death for you, and karma comes quick and swift. Paragraph 12, remember what happens is on you, LOL. There's a reply, are you threatening me? And the response, make sure you save everything. As always, give him my address as I will take care of him myself, LOL. There was a reply, that sounds like a threat to my life or someone else's life. That won't be tolerated. AF all, I assume that's supposed to be at all. Mr. Browder replies, you would think that, LOL. The 8th, paragraph 13, there's an email entitled liar. Within this email, Mr. Browder's entire email is cut off, but he then states multiple men at the same time, which is called a whore, which you have proven to be, LOL. Later in the same email, Mr. Browder states, karma is karma and it's a bitch and it will hit you hard. I will enjoy watching it as it will be very slow and painful. It may not happen for years, but it will happen. Paragraph 14, gross. I can't imagine what disease you have. I'm happy you aren't able to have kids anymore as you can't take care of the ones you have unless you have a man helping. Are those all of the statements that the parties are stipulating to?
Yes, Your Honor.
Mr. Gribbin, are there any additional statements that you believe are relevant to this determination?
I believe that covers them, Your Honor.
Okay, so sounds like we do have a stipulation to all of the facts necessary to for me to rule. Go ahead and make your argument, please.
The people allege that specifically six statements are threats. First, as we had mentioned earlier, the statement Mr. Browder threatened to blow Miss Stone's brains out was never made to Miss Stone and was incorrectly included in the people's filings and will not be coming in for the purposes of this hearing. Secondly, eat shit bitch and you worthless hole are vulgar, but calling someone a bitch for or similar name is constitutionally protected. The statements, you deserve what I dish out, you deserve your karma, and I am your karma, it is all good, your time is coming, are vague, conditional, and undefined as to means or timing. There's a not unequivocal, unconditional, or immediate and specific, as required under People v. Chase. And when Ms. Stone asked directly, are you threatening me? Mr. Browder responded, you would think that, LOL. This is a clear indication that Mr. Browder was intending these statements as jokes. And in applying the correct standard, a reasonable probability that the statute is unconstitutional as applied, the statements at issue are protected speech, or at minimum, there is a reasonable probability that they are protected, which is a standard for an as applied constitutional challenge.
We believe in the case law says that the speaker doesn't have to actually intend to carry out the threat. Rather, the focus is on protecting individuals from the fear of violence, the disruption that fear would create, and the possibility that the threat and violence would occur. And that's People v. Brown and People v. Counterman, taking into consideration the case law, the statements made here, and the role of the courts in looking at the facts, the plain language, the context, whether or not there's credibility in the threat, as well as the recipient's subjective reaction or response to the statement. And this is US v. Wheeler. We believe that the defense's motion should not be granted. We believe that in looking at the statements, in considering the context, the victim's genuine fear, and the other issues that are inherent in this case, that the court should uphold the prohibition of those statements and allow this to proceed.
So, Mr. Grubin, I just want to clarify, are you saying that the statements made, and the court has only taken this for purposes of this motion, not for anything else, but the statements made by Mr. Browder that have been stipulated to by both parties are true threats? Is that your position?
True threats and or obscene and or threatening bodily injury or property damage.
Can you point me to the statement made by Mr. Browder that you believe conveys a true threat? Does that make sense?
Yes. Eat shit, bitch, and you deserve what I dish out. You deserve your karma, and I am your karma, implying that he is the thing that's going to punish her. You worthless hole, it's all good. Your time is coming, meaning that her punishment is coming. I wish a slow and painful death for you, and that karma comes quick and swift. Again, he's stated many times that he is the karma. Remember, what happens is on you, LOL, meaning that whatever injury she may face is her fault. Make sure you save everything as always. Give him my address. I will take care of him myself. Meaning that he's going to take care of whatever it is that he needs to take care of. Karma is karma, and it's a bitch, and it will hit you hard. I will enjoy watching it, as it will be very slow and painful. It may not happen for years, but it will happen. So it looks like he's both indicating that she is just a hole for other things to fuck, and this is something that it seems like he's implying she's going to both suffer on her own, but that he's also going to be involved in the process of making her suffer, and that he's going to both potentially do things to her as well as whoever else she sees. And so it seems like there's a culmination of different things going on here.
Thank you. Ms. Gifford, anything further?
Just to reply to what the people just stated, all of those statements, none of those are unequivocal, unconditional, immediate, or specific, so they do not fall under what would be considered a true threat.
Thank you. So this matter comes before the court on the defendant's motion to dismiss for as applied unconstitutionality. The court has reviewed the motion, people's reply, your response that was filed. I also considered the stipulation that we just went through on the record. So the First Amendment, applicable to the states through the 14th Amendment, provides that, quote, Congress shall make no law abridging the freedom of speech. That's from Virginia versus Black, 538 U.S. 343 at 358, a 2003 U.S. Supreme Court case. Since then, the Supreme Court has held from 1791 to the present, the First Amendment has permitted restrictions upon the content of speech in a few limited areas. These historic and traditional categories are long familiar to the bar and perhaps to the general public. True threats of violence are one of the historically unprotected categories of communications. True threats are, quote, serious expressions conveying that a speaker means to commit an act of unlawful violence. That's Counterman versus Colorado, 600 U.S. 66. Pinpoint is 73 to 74. That's a 2023 case. In this case, the court has carefully reviewed all of the statutes, all of the contested statements. The court doesn't believe that any of these are true threats. Some of the statements referenced by Mr. Garibian are absolutely protected speech. Although it may be offensive, whether something is offensive is not determinative. Even if it is offensive that he sits back and says, well, I hope an act of violence occurs to you, that's not true threats. That is free speech. He is not conveying that he is going to inflict any of these things. Eat, shit, bitch, slut, are constitutionally protected because they don't convey that he is going to commit violence. Again, him speculating on diseases, although offensive and vulgar and rude, those are protected because all speech is protected unless it is specifically excluded from protections. Fighting words is what Mr. Garibian is proceeding under, so that's what the court is reviewing. Whore, all of these things, while vulgar and offensive, are not indications that Mr. Browder is going to commit any acts of violence. This is paragraph 7 from the defense motion. Make sure you save everything as always. Give, and then it's bracketed, Mr. Smith's boyfriend, my address, and I will take care of him myself, LOL. Again, that I don't know what he means. There's not an explicit reference to imminent violence. I believe that it's also, he's saying, I will defend myself. If he comes to my address, then I will take care of him. This is not, I'm going to hurt him. I'm going to assault him. I'm going to commit some kind of violence. And the court is allowed to make inferences. But the court doesn't have anything in there that the defendant recklessly conveyed an allegation of physical threat. Karma is karma, and it's a bitch, and it will hit you hard. I will enjoy watching it. Again, that is not a true threat. So that's paragraph 5. You deserve karma, and I am your karma. And then paragraph 8, karma is a bitch. Karma is karma, and it's a bitch, and it will hit you hard. I will enjoy watching it. So those two together are, the court believes, closer. But he explicitly says in paragraph 8, I will enjoy watching it. He doesn't say that he's actually going to do anything. The court doesn't believe that conveys a true threat. The court is going to find that although offensive, that all of the statements that have been offered are protected speech, protected by the First Amendment, because the court does not find any true threat for any of those statements. So the court is going to grant the motion to protect all of those speech, all of those statements. Mr. Gribbin, any request for further record?
So would that effectively dismiss the case? Because we wouldn't be able to, we don't have anything else to proceed on.
So that is the ruling of the court. You can decide how you want to proceed. So with respect to the trial, it is set for August 5th. I understand the people may not be VRA for dismissal. I am not dismissing the case. What I am doing is just issuing rulings, and these are constitutional. This is constitutional suppression. So Mr. Gribbin, how would you like to? This one, although I don't like leaving cases on when they're not likely to go to trial, I do recognize that you need some time to process this. You need to have VRA. Is your request that we leave it on for August 5th?
I suppose let's leave it on for August 5th because I have to at least reach out to her. But in effect, we wouldn't be able to proceed to trial if the statements are all restricted. So we can leave it on just for VRA purposes.
Well, and also, I'm certainly not encouraging it, but the people, this is a constitutional suppression. The people could decide whether to do an interlocutory appeal. The court will acknowledge that this would constitute critical evidence because, as you just stated, without the statements, the people can't proceed. So that will also give you time to make that determination. So, Mr. Browder, speak with Ms. Gifford. She can tell you what all of the rulings today meant. You'll be required to reappear on August 5th. Well, let me back up. Ms. Gifford, are you announcing ready for trial?
We are ready for trial, Your Honor.
Okay. So you will need to appear on August 5th. We'll figure out what's going on. The people have to make some decisions on how they'd like to proceed. Any questions?
No, sir.
Okay. Thank you. Ms. Gifford, anything further?
Nothing further, Your Honor.
Mr. Gribbin?
No, Your Honor.
Okay. Thank you. Have a great weekend.